SGM College, Karat. It is my great pleasure to introduce our distinguished speaker today, Mrs. Gauri Govindrao Wagmare. She is a highly accomplished professional with expertise in intellectual property right. Mrs. Wagmare is a Kiran IPR scholar from the Women Scientist C scheme in 2019 and registered a patent agent and SIPP, facilitated and IP Mitra. She is also pursuing RTTPP accreditation with STEM Global, having obtained 67 credit. She holds a bachelor degree in a mechanical engineering and a master degree in a machine design. With over 7 year experience in IPR, Mrs. Wagmare specializes in FTOs, CS, patient reports, patenting, drafting, FER responses, and technology scan. She also has over more than 5 years of teaching experience, known of her strong managing skills and excellent communication. She excelled in guiding a start people through IP complexity and supporting incoming challenge innovator. Mrs. Wagmare committed kindness and altruism is evident in her efforts to support innovative who may not have a financing means to protect their invitation. She recognized the increasing importance of IP in gaining a competitive advantage across industries and the necessity of the strategy. In 2019, Mrs. Wagmare founded Gauri Vandana Legal Services, a firm providing high quality services in patent, trademark, design, and copyright both in India and internationally. The firm also offers IPR training program and employs a team seasoned professional and a part-time. So, in an era where intellectual property is paramount, Gauri's strategies, insight, advocacy, and are catalysts for succeeding for individual and organizing alike. Please join me in welcoming Mrs. Gauri Govindra Wagmare. Miss Gauri ma'am, you can start your lecture.
Yeah, thank you, Aarti. So, hi everyone, this is Gauri. So today we are going to talk about the importance of IP and types of IP. Myself, I am Gauri Wagmare, Managing Director, Gauri Vandana Legal Services. The firm is located at Latur and Navi Mumbai, and we are providing the IP protection and prosecution services and tech transfer services to our clients. So let's start with the concept of IP. So the concept of IP, what do you think? How much old is the concept of IP? What do you think? You can type in the chat box. So the concept of IP is not the new one. It is much old. And in one of the court cases in 1845, Justice Charles W. Wrote that we can protect the intellectual property in this way. It is nothing the protection of labors of mind, productions, and interest are as much as man's own as the wheat he cultivates. It means it is come under plant breeders' right and or the fox he rears. So the concept of IP is very old and it is not the new concept. But the awareness of this thing is very less in our country. And that's why we are organizing this type of events actually. And thank you for this type of event. Special thanks to Mr. Deshmukh. Let's see intellectual property and what you think about. So anything which is originate from the mind, it is called as intellectual property. It comes under human intellect. It is a creative work. It can be a artistic work. It can be a technical improvement. and it can be a knowledge expressed in the document. So intellectual property can be a patent, can be a creative work of artist. It comes under copyright. It can be a knowledge expressed in the document. So the books comes under copyright. These rights are territorial in nature. What do you mean by territorial? It means the boundary of the nation defines the right. So in India, Patents Act 1970, it defines the Patent Act for India. So it is a territorial rights. Also for each and every IP, the different acts are there. So the Bear Act is there for each and every IP. There are nothing but 9 IPs, and we are going to see that. Also, the specific term of protection is given to each and every IP. This is a limited time period which is given. In that, the owner of the IP can exploit their creation and create the wealth. The example of IP is like an invention, a mark, a song, like that. So, so many clients come to us that they are having only idea. So what do you think? The idea is patented? You can type into the chat box, so we can make the discussion very like two-way discussion, communication. So as such, ideas are not patented. Only when you come with some invention, then that is patented. So this is one of the thing which so many people don't know, that idea is patented or not. So idea is not patented. The invention is patented. Let's see in the next slide. There are different types of IP, and they are categorized in this way. So few of the IPs need registration from the government. Few of them are not needed any registration from the government. So the registered IPs are like patents, trademark, plant breeders' right, industrial design, geographical indication, and semiconductor integrated circuit layout design. So they need government protection, and without that, we cannot exploit that, or we cannot stop the infringement cases for the same IP. Copyrights and trade secrets are come under non-registered rights. So even if we are not going for the registration of these things, they are getting the protection. Also, the academics right and industrial rights property. In this way, the copyrights are termed under academics, and patent, trademark, plant breeders right, industrial design, geographical indication, and trade secret, SICLD, they comes under industrial domain. So let's see the term of the patent. Before that, I would like to give you the clarity over how the patent system works. So patent system works, suppose you have one invention, and you are going for the patenting that invention, and it is patentable, and you got the patent over that. So the term for that patent, you will get 20 years of time. In that, only you are getting the monopoly right over that invention, and you can commercialize it or market it or make it and sell and get benefited by that patent. So this is the type, this is the 20 years terms given to the patent to get the monopoly right over that patent. In case of trademarks, we are getting 10 years of term, and after expiring the 10 years of term, we can renew that patent for next 10 years. So in that way, we can renew the trademark in each 10 years. In case of industrial design, initially the term is 10 years, but if 10 years term is over, you can extend it up to 5 years after renewal. In case of copyright, you are getting benefited very large. So suppose you are the author of copyright, then you are getting the protection or the life term of copyright up to your life term. And plus after the death also 60 years you get benefited, or your family members get benefited. So it is inherent right, and it is transmitted to the next generation. In case of GI, you will get the 10 years of benefit. Also, you will renew it for the lifetime. So this is the term of IP. So why IP is important and what are the objectives of the IP? Generally, IP is important for the technological development. It encourages the technological development. Suppose you are having the invention, you filed a patent, then it will get published after 18 months, or if you want to publish it before that, also there are chances. So with Form 9, you can publish that patent application. Once it is published, then it is open to all. So you can do the research on the published document. So in patenting anything means you are giving your technology for the further development. So IP is nothing but one of the important thing which gives the way for further development. Okay. Another thing which is important and we are getting benefited by IP is that we are getting a huge amount of foreign direct investment in our country through IP. In case of tech transfer, if you license it to the other players in the industry, then monetary benefit is given to the owner of the IP in way of upfront amount and licensing amount. Also, if you are a creator of the work, you are having a copyright, then awards and recognition is given. In case of film industry, if you created a good type of film, then definitely it is recognized and awarded. So these are the things and the objectives of IP, and the country and the whole cross-border trade is benefited by means of IP. Let's go towards the next slide. So let's see the first IP, the most important. Patents is a most important IP. How many of you know about the CRISPR-Cas9? You can type into the chat or you can unmute and talk.
Yes, approximately every microbiologist know about CRISPR-9-Cas9 protein.
Yeah, yes. So before CRISPR-Cas9, there is CRISPR-Cas7 and other proteins are there, other tools are there. And it is very groundbreaking technology in gene editing. Hello. So this gene editing tool is patented. And also the technology that is patented by Apple, that is shake to charge technology. So this type of technologies are very revolutionary and they will create a huge impact on society. So patents is nothing but when we patent something, it means they are giving the exclusivity over that technology, exclusive right and privilege on that particular technology to exploit it for the 20 years. It is given by the government of the country to one or more individuals. So it is given to the group of individuals as well. And the term is limited, that is 20 years. Let's see the next one, which is also important, that is trademarks. When we see anything like when we purchase anything, or when we purchase any services, suppose Uber, Ola is there, the app is there. So they are having a specific trademark for that. Okay, so Coca-Cola bottle, the shape of the Coca-Cola bottle is also comes under trademarks. So there is a confusion between trademark and industrial design sometimes, but under trademark also we can benefit the if the Coca-Cola bottle shape is there and we want to protect it, so under trademark also we can protect it, or under industrial design also we can protect it. So but there is one thing that only you can go for one IP at a one time.
काय समजून काय तुला लिहाय इमली खायचं तुला हा अरे मग देतो की तुला हे बघ
Can you mute, sir?
हे बघ मी अजून ओपन केलं भरपूर आहे आपल्याकडे इंग्लिश, तू काळजीच नको करू. दिवसभर इंग्लिश का
So trademarks
हा
nothing but the
तीन महिने आलो
signs,
होतं कोणतं
symbols,
इथं घेतलं होतं.
alphabet,
जातो ना आम्ही
and etc. So trademarks are the sign. So you can trademark your sign as well. So in case of Sachin Tendulkar, he trademarked his own sign. The symbols also we can trademark, or the alphabets we can trademark. So what trademark define? Trademark is nothing but distinguishing the goods or services from the goods or services of another trader. So it will show that from where the goods and services are originated. So they will distinguish the kind of goods and services from other players of the industry. Okay, so that is the benefit we are getting from the trademark, and that's why there is very less confusion between the consumers. Suppose you are having a trademark like Nike, and if someone infringed that trademark and make a different kind of shoe and in the market, so by looking at the trademark only, we can see that this is not the original product. So in that way, you can differentiate the goods and services by looking towards the trademark only. So there are few examples. That is the slice written on the bottle. It comes under trademark. It can be a label on the chocolates or label on any bottle or the shape of the bottle. Okay. Also, the ringtone, Nokia's ringtone, as you know that, it also comes under the trademark. So this is nothing but the musical trademark. Also, the taglines or punchlines, it comes under the trademarks. When you use the trademark in such a way that it is known to each and every person, and it will become converted into the generic trademarks. It is like a Xerox. So copying the material, it is called as a Xerox, as we know that. So we are not using the term that is copying, but we are using Xerox instead of that. It means that the trademark Xerox, it becomes generic. Okay, let's go to the next slide. Copyright. As we well aware about the copyright, it is one of the oldest IP, and it is the first IP. Before all the IPs, only one IP is there, and it will comes under Copyright Act, and it will cover the original literary and artistic work. Also subsist in original literary, dramatic, musical, artistic, cinematographic films, and sound recordings. There are so many rights comes under the trademark, like rights of performance, rights of broadcasting organizations, database of gene sequence listing, also the computer algorithms. It will come under the copyrights. Okay. So copyright, it will cover huge amount of database, and it is the first IP in the world. Let's go to industrial design. So industrial design, it will cover the aesthetics of the appearance of the product, and it will protect only aesthetic appearance of the product. Is it concerned with the looks of an article, not how they function or underlying technology. So technology, which doesn't matter in the industrial design. In industrial design, there is only one claim, which is covering the appearance of that product. Look, cover, and how it feels. That's it. Not more than that. The technology is not covered under industrial design. Technology is covered under patents. So the general rule and industrial design consists like it will consist three-dimensional features of the product or shape, like Coca-Cola bottle, it comes under trademark as well as industrial design. There is ornamentation patterns, 2D patterns are there, lines and color combinations are there. They comes under industrial design. So combination of one or more features, they are come under industrial design. There are examples given like design of handicraft, shape of BMW sports car. Also the design, there are printing on the on any cardboard printing. So they comes under industrial design. Let's see the geographical indication. It is also very important trade IP, and GI is nothing but giving the origin of that product, that is a characteristics equivalent or reputation of that product. It is related to the GI, and due to natural factors or methods of manufacturing or other factors of that particular area, the product is different than that. So in case of Nagpur orange also, GI is given because of the geographical factors. The orange are famous. They are having a different natural factors. Okay. In case of Darjeeling tea also, it is one of the known geographical indication. And Campaign of France, it is also a geographical origin, geographical indication. So GI are also protected under intellectual property rights, and they can be renewed for the lifetime. And the different skill workers are benefited under this GI by protecting it, and they can start their own business related to that product. So as India is having a very dynamic nature of geographical area, and also the cultural differences are there. So there are so many things we can do regarding GI. Let's go for trade secrets. So as we know that the trade secret, it is not registered, but it can be kept secret. It can be a business related information like financial information, customer list, or other things, other analytical data. Or it can be a technical related drawings, models, or prototypes, or algorithms. If you keep it secret for your business purpose, then you will get flourish. So trade secrets example, I can say that Google's algorithm is there. So no one knows about that. And it is one of the biggest trade secret. And due to that, Google is a global player. And so much data they are having with them. And once they are having that huge data, so they can manipulate the market as well. Another thing is that in case of McDonald's, they are having a different types of sauces. So no one knows about the formulation, how they are prepared. And it is one of the trade secret. In case of Coca-Cola as well, the formula is not known to, earlier it is not known, and it kept as a trade secret. So for a business things, you need to keep few things which are technical in nature, few information need to be secret within your core members only. So that is nothing but the trade secret. Traditional knowledge. So anything which comes under traditional knowledge, it cannot be patented under Section 3 of the Patent Act. So under Section 3P, traditional knowledge is not patentable, but it is one of the intellectual property as and it is preserved under TKDL library. So traditional knowledge digital library is there. And if someone want to make the use of traditional knowledge and patent it as it is, then it is not possible. As we know, the famous revocation case of Haldi patent, that in USA, they want to treat a cancer by using curcumin, which is which is present in turmeric. And in India, each and every person knows that turmeric is used for cancer treatment. So the patent is get revoked because traditional knowledge, it is not get patented under Patent Act. So it comes under IP, but we cannot patent anything which comes from the traditional knowledge. But we can patent if you make the enhancement of efficacy in the drugs by using traditional knowledge, but you can extract some things by using a specific method, and then you can make the drugs, then it is patentable. So you need to check for the Section 3 of the Patent Act before going for patenting, which is related to traditional knowledge. Another important IP is plant breeders' right. It can also called as a plant varieties right protection. It is available for new varieties of plant. Suppose someone invented someone modified the genes for a rice crop and make a drought resistant rice crop, or different types of black gram, which are having good societal impact, and they can be preserved under natural calamities, then that type of plants can be preserved under plant varieties right. And it is very important and protected. Varieties of agriculture, horticulture, and forestry need to be protected under the era of global warming. Let's see the next one. This one is very important. Semiconductor integrated layout, circuit layout design. This is nothing but semiconductor integrated circuit design is nothing but called as a chip or microchip, and it can be digital or analog. So the examples are counter microprocessor in your laptop or in your phone. You are having a microprocessor chips, so they are plotted on some circuit. The integrated circuit is there, and it is one type of IP, and it comes under SICLD. Layout design, it refers to the 3D character of the element and interconnection of an integrated circuit. So these both things are very important. Sometimes it comes with patent, and separately they are protected under SICLD. So example is photographing mask used to etch the process of chip. It is the example. And yes, so to protect your IP, you can contact us on this email ID and website. If you have any question, you can ask. Hello.
Miss Gauri, can you hear me?
Yes, sir.
Yeah, related to CRISPR-Cas9, what component is patented was not clear much.
What component?
दूसरा देख तो अभी मैं लगाई थी बाहर रखा है तेरा नहीं दूसरा देख
Can you hear me?
Miss Alka Soni, can you please mute yourself?
और देख ले बाहर सफेद भी है एक किलो इसको भी निकाल के मेरे हाथ में फोन है
Sir, yeah, sir. So in
Alka
case
Soni
of,
has to mute her mic first.
yeah,
No,
yeah.
You were telling about the CRISPR-Cas9, no?
Yes, sir.
Yeah,
Yes.
we patented.
So in case of CRISPR-Cas9, the Cas9, it is a protein which is used to cut the genes and attach it to the different polydynamic repeats. So it is a different type of a gene editing technique, sir. And
Okay.
the new protein, which is Cas9, is used for that. So it is protected under patents.
So you mean now it is not available for the researcher to use?
No, it is available for the researcher. For this type of techniques, if you want to take it, then inter-university licensing, you can do that by means of a material transfer agreements. So,
or otherwise you have to purchase from the supplier.
no, you cannot purchase. You have to make a material transfer agreement in this case, sir.
No, is it available for
So
the
MTA is necessary in that case. So you can do the MTA with Cornell University. You can take it, and yeah, in that way you can do it. You can do the research, but in the MTA you have to mention that it is used for the research.
But otherwise it can be used for research. We can use.
Yeah, for research you can use.
Geographical indicator, how did they determine, by the way?
Geographical indication, it is nothing but suppose for a particular territory,
Okay.
there is a thing or there is a skill or there is some plant is there which is originated from that geography only and nowhere in the world. So GI is given for that particular territory.
And who has to decide that?
Can you give example that matlab,
No, now you said Nagpur Santra is a
yeah,
geographical indicator.
yeah, yes.
Now
It is
I will
having
say,
GI tag.
I will say that Kurk Santra is also there. Who has to decide?
Sir, their combination of medicinal values or the vitamins present in the Nagpur orange, it is more superior than the other types of oranges. So that's why the GI tag is given to the Nagpur orange.
Looks quite convincing. How many days in India actually nowadays it's taking for granting the patent? In Pune, some office is working, no, on the patent search and all these things.
There are so many offices, sir. So legal firms are there, as
Yes.
like me. The patent office official office is located at Antoff Hill, Mumbai.
Wonderful.
Yeah.
If somebody claims a false patent,
Mhm.
no, you could claim because you are not disclosing the information. And then
What do you mean by false claims, sir?
false means the claim which they are not telling it is not cannot be substantiated with the result or the scientific data.
If you are patenting anything which is not proved, or
Mm.
if you don't have a proof of concept established with that patent, and if you don't have the that is explanation part of it, then it is objected by the government of India. So in first examination report, there are
Yes.
some citation it will come and it is objected, and sometime the pre-grant opposition also comes.
So they have to withdraw such patents, right?
Yeah, yes.
Or it will not be granted.
If you are sure about your patent, your technology is different, it is novel, it is innovative, it is applicable to the industry, then you can fight for it. You can write your reply to the objection in the FER.
Okay. What is the exact nature of your work?
My nature of work is that we are helping innovators to develop their technology as well as to prosecution stage, that is filing the patent, trademark, copyright and all IPs, and also to commercialize it.
Wonderful, wonderful. Other than patent, you don't deal anything.
We do all IP.
If it is only a product, is not
It
not
is
a patent,
product, and what is its application?
to health benefits, consumption.
It comes under patent, sir.
No, it is not filed a patent. It is a technology developed as in the form of product or
It
process.
is in the form of?
Process or product.
Yeah, it is patented. If it is a new process, new method of doing something, then it is patented.
No, if it is not patented, will you take it as a product development or technology development?
You want to improve it to
Yes,
get
yes.
the patentable?
Yes.
Get
No, not.
benefited
No,
by
it-
patent. That is
it
to,
can-
you want a technical advancement over that.
Yes, yes. It cannot be.
Yeah, we are providing that as well. Yes.
Mhm. I think one more my question was there in the chat box.
Okay.
You can just display your slide number 16, I think so. Some other viewers can actually.
So your question is benefiting of trademarking signature.
Oh, yes, exactly.
Yeah.
What is the
Okay.
benefit?
Okay, sir. Actually, Sachin Tendulkar, because if you want to trademark your signature, also you can do that. But
What is
unless and until you are so much famous, why you are going for trademarking it?
First you have to become famous and then you can go for a trademark.
No, I'm just saying that if
Not
you
easy.
go for it, then if you are famous, then you go for it. Otherwise, why you are investing your money on that?
And who has to grant that one, by the way?
Yes.
Who has to grant that trademark?
Who has to grant?
Just like
Trademark
patent.
registry will grant the trademarks.
or patent agency only?
No, trademark registry.
Okay, trademark registry.
yeah.
Okay. One more, I think one small question was there related to copyright. It is actually the copyright. What we cover is the publisher, not the authors, right?
Publishers, we are giving the copyrights to for publisher, we are giving few rights of to do make the copies of that, and yeah.
Yeah, so whatever actually book which we publish is covered under copyright by the publisher. You don't have anything the claim to the authors.
No, if it is your invention, then obviously if you are going for a copyright and submitted the document in the copyright registry, then you are getting the copyright over that, no?
So the author
Publisher is
okay.
only just printing it and doing the other things, publishing it. That's it.
Okay, thank you, thank you. Very good presentation.
Yeah, thank you, sir.
Excuse me, ma'am.
Yeah.
Hello.
Yes, hello.
Yes, yes. My question is also related to copyright.
Yes.
So I have been this question. I have this question in my mind for a long time. Suppose I prepared an image and I copyright that image because I prepared it by myself, and it is giving a unique information. At least to some part of it is very unique.
Okay.
Right now, I want to publish a paper in which I will keep this image. So can I keep it, because publisher will ask an agreement that all the copyright goes to the publisher after publication. So will there be any conflict, or the image copyright will remain with me?
Image copyright is remain with you because you are the owner of that image. So it is with you. But if you are transferring it to the other party, then the agreement between both of you, what you are writing in that agreement, it will also plays the important role. If you want to transfer the whole thing to them, then it will go to whole totally to that person. But if you want to preserve your rights over few things, then definitely it's yours.
Okay, so while signing the agreement with publisher, we have to mark that this image we don't want to give the copyright.
Yes. While making the agreement, you have to check for each and every clause.
Okay.
Yeah.
Thank you.
Thank you. Yeah, any other questions?
Ma'am, hello.
Yes.
Yes, one more question I want to ask is, so once we file a patent, it gets published in the journal, right? From patent office, it gets published. Then we have to defend it. So how much money do we have to spend in when we are going to defend, and for the grant I'm saying?
Are you a startup or are you an individual?
Individual researcher.
Individual. Okay. And
working in
patent
an
is related
institute.
to?
Microbiological research.
Acha, okay. Okay, first step is that what I suggest before going for a patenting, you have to go for search report. So once your search report is clear and your patent is patentable, then you go for patent. Okay. So for patent filing, the government fees is 1,600. Okay. So for Form 1 and Form 2, you need only 1,600 as an individual. And if you are startup, then also the same fees, 1,600. Okay. So if you are filing Form 9 for early publication, then within 1 month, it will get published. Okay. And if you don't want to go for Form 9, so within 18 months, it will get published. Okay. And you have to apply for examination as well. Then and then only the first examination report comes. Otherwise not. So there is very lack of understanding between the academic persons that they think that once it is published, it means it is granted. But it is not the case. It is published means it is open to all. It is not granted. Okay. So you have to file Form 18 or 18A for making the examination for your patent application. Okay. You can expedite
Okay.
the examination process by filing Form 18A with 18. Okay. Then first examination report will come, and then you have to reply to that examination report.
Mhm.
On each and every objection, you have to write down the reply, and then submit it to the patent office. Okay. Then after, hearing comes.
Okay.
And in hearing, it is granted or rejected. That is the process. So
So
for
during
this
the
whole
hearing, we
process,
need
yeah,
some. During the hearing, we need some attorney to represent our case, or can we defend ourselves?
yourself you can do that, but I will suggest that to go for a good patent agent who will help you, because what happens now, patent grant is okay, suppose it is granted, okay, but if you want to go for technology transfer and if it is very poorly drafted, then no one can protect your patent, because
Okay.
drafting of patent is need to be very precise, and it need to drafted in a different way to protect your IP.
Okay.
Yeah. So you have to go to the good registered patent agent. Okay. Don't go to the lawyer, because lawyers sometimes they don't have idea about the science and tech behind that. So go to the registered patent agent. Also, you can come to us as well. And I am a SIPP facilitator. So in free of cost, if you want to go for patent as well, we are giving you the benefit of SIPP scheme as well. But for that, you have to register a startup. So in individual case, you cannot go. So if you registered a
Okay.
startup, then under SIPP scheme, you will get benefit from Government of India.
Okay. Great. Great. This individual thing I did not understand. So I am working in a private university.
Yeah.
I am treated as an individual when I will file patent, or is it the university who will get the credit more because I'm
So
working
tell
there
me
using
about
the
the project which is come under the university. Means university is providing the support system to
lab
that
facility.
project.
Yes. Lab facilities of
So
institute.
it means that you will considered under work for hire under. So it means that the applicant is in university or industry under which you are
Mhm.
doing the project. You are come under the inventor, not on the applicant. But applicant is having the rights. Inventor is also having the right in the share, but they are having minimum rights. So yeah, in that way it will be.
Okay. How about the fees? Fees will be same or different? Initial fees that you said.
Fees are under SIPP scheme, we are taking only for search report, that is 10,000, and other things we are not taking any fees. Only government fees you have to pay. That's it.
Okay. Great. So, ma'am, I will be in touch with you, and because I have so many things to actually discuss, so I'll be in touch with you regarding this.
Okay. Okay, no
Yeah. Thank you.
problem.
Thank you
You
so
can
much,
take
ma'am.
my contact number as well. Yeah.
Yes, I have written it down. Yeah, I
Yes.
got it.
Gauri, you can keep that slide number 16, your contacts detail.
1 minute.
You can display the slide number 16.
Yeah.
Oh, very good.
Hello.
Hello.
My question is how long it may take to file a patent actually?
For filing a patent.
Yes.
Is the work is totally complete?
Yeah, work is completed. And here also I have a doubt. If we are developing a method to formulate a product, okay, if the procedure is novel, it can be filed, no?
Yeah, yes. Method is also patented.
Patentable.
If
So,
everything is ready with you and everything is validated, then 15 days is for search report preparation and 15 days for the making draft and other forms. So at least 30 days time is required.
so after the product development, we have to contact you or
Yeah.
for
After
filing the
product development, you can contact me. Also, we are having a team for product development as well. If you have any things regarding the same, also you can contact.
Okay. So financially, there will not be any benefit, I feel. Only the patentable. Yes, the product is patentable. Only that one will be there.
No, so you want to get benefited by project or not?
Yeah,
You want to, na? So
yeah.
yeah, okay, that is your motive, na? So you get benefited. Okay, so so you have to check for the tech assessment for that project, and also we are providing the tech transfer services. So if you want to license it out, then
Hmm.
also we are giving you the, like, we can help you in that case.
Okay.
So you can come on one-on-one discussion. Take my contact number.
Okay.
How are the service charges, by the way, Miss Gauri? How
Service
much?
charges, you want a list of all because
Yeah, minimum, or how you have offered previously one or other case studies or example, do you have that some researcher approached you or institute approached and then you have offered them services from the beginning till the end?
yeah, under SIPP, you are getting benefited much more. But the case is that you need to register for your startup. That is the thing. But individually, if you come, then also like Gauri Mandana, they are having the scheme that for economically weaker inventors also we are helping. And our fees are very less as compared to other players.
New authentication request.
Wonderful.
Very nice, Gauri.
Thank you, sir.
Your talk was really excellent. And I will repeat it again and again. The reason is that it takes a time to convince the people.
Yeah.
People need it, but they don't understand that we need it. So we'll repeat it again and again.
Yeah. Yes.
Okay?
Yeah, sir. No problems.
Yes. So I request again Dr. Aarti to express vote of thanks. Aishwarya is here, but she is traveling. That's
Yeah.
why she is only attending. Aarti, you can. Aarti, whether you are there? I think Aarti is not there. Aarti has. Okay. Okay. So it's all right. Now you see, I should not express thanks to Gauri because she is my family member. So, but she has done a wonderful talk, and I know her capacity, her potential, her abilities. And definitely in life science branch, I want to give more exposure to Gauri. And all our teachers from different corners of India, they will attend, they will take your help. And very few of them are knowing regarding patenting and how to popularize our invention, how to earn money via our invention. So really, it was an excellent talk. I am thankful to Dr. Prakash Halami also. Prakash Halami Gauri. Prakash Halami is a very big scientist of Mysore, CFTRI. And he is regularly joining. In addition to that, about 20 participants were there who have taken advantage of today your lecture. So it's all right. We'll conclude now. And I thanks all participants for attending this event.
Thank you, sir. Thank you, everyone.
Thank you very much.